Welcome to Case Flash, brought to you by the CBA Family Law Section. I'm Sam Schoonmaker, and with me today are attorneys Jill Plancher and Alan Palmer. Today's Case Flash addresses new procedures for appointment of guardian ad litem and attorneys for minor children in custody cases, as well as a new code of conduct that's applicable to attorneys for minor children and guardian ad litem. This Case Flash will not address procedures relating to fees and the recording of fees. Attorney Plancher, in some cases, a guardian ad litem or attorney for a minor child is appointed by agreement. Can you describe how the procedure is going to work under the new rules that we have?
Sure. So just like the procedure that happens now, if a party moves for the appointment of an attorney for minor children or for a GAL, and the other party agrees that that's necessary in the case, counsel or self-represented parties can confer on who they wish the court to appoint and can make that selection known to the court upon the motion making it onto the calendar. At that point, the court can grant the motion for appointment of a GAL or an AMC and approve the selected person, of course, subject to their availability. Also at that time, it will be important under the new statute for counsel to prepare a stipulation.
Attorney Palmer, there are also instances where there will not be an agreement on appointment of a attorney for the minor children or guardian ad litem. What happens in those cases?
In those cases, there's a three-step process which could involve three separate hearings. The first determination that has to be made by the court is whether an attorney for the minor children or guardian ad litem is even appropriate under the circumstances. Assuming that answer is in the affirmative after a hearing, the court is going to be required to submit a new form, which would be designated JDFM 229, which proposes 15 alternate names to serve as attorney for the minor children or GAL. The parties then have a mandatory report back period not to exceed 14 days to either agree upon the appointment of AMC or GAL or to come back and have a hearing as to who the court's going to appoint. Once the court makes that appointment, the next step is to delineate the duties and responsibilities of the representative for the children and to establish a fee schedule. Another new form has been created for that purpose as well, which has that separated out into various sections.
So what are the kinds of duties that a GAL or AMC could be appointed to handle?
Well, I have one question for you, though, Attorney Palmer. It doesn't seem to me that the court would permit argument on the selection of an AMC or GAL if there's no agreement after that second stage. I think the court may just simply select a name from the list that was provided to the parties if they failed to reach agreement.
I agree with you in part.
Okay.
I think that the court will hear specific objections to certain nominees if there are specific objections, but I agree with you that if there are no objections, the court is going to make a decision based on the names that it proposed.
So that'll be interesting. We'll have to see how that evolves.
When a person is appointed, certain duties are going to be assigned to that person. What are the kinds of duties that are going to be assigned?
So right now, an AMC or a GAL who's appointed in a case is guided by the dispute. So in other words, if it's a fully contested case where both legal custody and residential access schedule, all of that is in dispute, then the GAL will probably do an entire investigation into the nature of the family relationship, the family systems, any mental health issues, education issues, do home visits and the like. It's a full comprehensive analysis. Under today's, or what will be tomorrow's statute, there's going to be specific duties that are going to be required of a GAL or an AMC that are going to be set out by the court that probably will track these same types of duties that have been completed by GALs and AMCs, but they'll be specific, and it'll be important for counsel representing parties to pay attention to those types of duties because it will either limit the work that the GAL can do, or it will be an expansive work. And it'll be important for council to be careful about asking the court to require the GAL or AMC to engage either in a full investigation to include home visits, conversations with children, with therapists and the like, or a more limited role that could, for example, be limited to meeting with the parties and crafting a parenting access schedule.
I think that the form, the JDFM 227, contains a large laundry list of duties and responsibilities for the attorney for the children and the guardian, but it's not exhaustive. And I think the practitioner needs to pay close attention to the fact that not every situation is going to be covered by the form. For instance, we discussed the case of Gill versus Gill involving exercising the privilege on behalf of the children. The proposed form does not include privilege issues. So if the guardian's going to have to raise an issue of privilege or waive an issue of privilege, that should be indicated on the form.
Another important issue, I don't mean to cut you off, is that cases evolve over time. An issue that wasn't apparent at the beginning of a case may become so as the case matures. And if the GAL is limited, or the AMC is limited by the duties that were set forth at the beginning of the case, it will be incumbent upon the GAL or AMC to seek court permission to expand his or her role.
And what would be the procedure for seeking court permission to expand one's role if you've already been appointed in a case?
The judicial website provides a form for guardians to ask for an immediate status conference, which basically encompasses three situations. It encompasses an emergency situation where the parties and the guardian requires the court's immediate attention. It discusses non-emergency situations where a status conference will be assigned in due course. And it also deals with the situation where the guardian's not being paid. So that form can be filed at any time the parties either request that the guardian do something outside the initial appointment, or if an issue comes up and the guardian feels that he or she needs to go beyond what has already been ordered.
Turning now to the code of conduct for counsel and minor children and guardian ad litems that's now been promulgated by the judicial branch. The new code of conduct applies to attorneys for minor children and guardian ad litem. Starting briefly with attorneys for minor children, the new code of conduct doesn't seem to add much to the existing case law in Karuba. It's a very short description of what counsel can do. But now turning to the role of the guardian ad litem, Attorney Palmer, is there anything in the code of conduct that caught your attention?
Initially, the subsection 5 of the representation of the child's best interest by the guardian deals with any privilege that may exist between the guardian and the child. It's specifically now delineated in the code of conduct that there is no attorney-client privilege between the guardian and the child. What I found interesting about that, though, is what's missing is the attorney for the child. And the attorney for the child would still be bound by the rules of professional conduct involving attorney-client privilege within those conversations. So I think there is a delineation between, or a differentiation made between AMCs and GALs for that purpose.
Mm-hmm. There's also a new provision in the code of conduct for communicating recommendations. Attorney Blanchard, what does the code say about that?
So this new code indicates that if a guardian is going to make a recommendation, the guardian shall do so by speaking directly to the litigant or counsel if the litigant is represented. I don't believe that this requires the guardian to make such a recommendation, but only provides for a mechanism for how the guardian should do so. So in other words, if the guardian is inclined to make a recommendation, she must do so directly to the litigant or to counsel, unless otherwise directed to by counsel.
And I note that the new form delineating the guardian's responsibilities does not provide for the guardian to make a recommendation. The closest thing that it gets to is reporting back to the court on some specified interval.
The code also now deals with conflict of interest. Attorney Palmer, what does the code say about conflict of interest?
This is actually pretty interesting because this sort of ties Karuba versus Moskowitz, which set up this idea of quasi-judicial immunity for guardians ad litem, and sort of melds it into this code of conduct. In subsection 2G, the guardian is not only required to avoid an actual conflict of interest, but also the appearance of a conflict of interest. And that applies not only to the guardians ad litem, but also to the attorneys for the children. So the attorney for the child now has a heightened responsibility under this code that he or she would not necessarily have under the rules of professional responsibility.
Looking at the attending hearings under the new code, what does that, what hearings must a guardian ad litem attend?
It's clear from the new code, and I think from our practice, that attorneys for minor children and guardians are required to attend all hearings where the interests of the children are impacted. Any issue that is substantially within his or her scope of duties as delineated by the court in its orders, if those issues are being raised or dealt with in any manner in those hearings, then the guardian ad litem and the AMC would be required to attend those hearings. I don't know that this would also apply to depositions taken out of court. There's a question as to that, the applicability of the code of conduct as to depositions. I think it probably would, and I think that attorneys and guardians will be required to attend depositions if the deposition is going to be impactful on the duties as set forth in the court's orders.
As a rule of thumb, it might be a good practice to put on the form that you will be attending depositions as well, because it's not specifically listed on the form either.
There are situations where a child will be in imminent danger. What does the code provide for when a child is in imminent danger?
The code of conduct now places attorneys for the children and guardians in a situation where they're almost mandated reporters. And I say almost mandated reporters is because the code places the guardian and the AMC in a position where they have to bring it to the court's attention immediately if the child is in imminent danger. It doesn't mean that the guardian or the attorney brings it to the attention of DCF, but to the court. There's a savings clause, quote-unquote savings clause, that if one of the parties or the court or DCF has made a referral to the court or to DCF, then the guardian is relieved of the responsibility to bring it to the court's attention. So that obligation only comes into play if nobody else has reported it.
So as a practical matter, how does this work when something happens off hours on a weekend or Friday afternoon? How does this going to practically work?
Well, I think that the duty still applies. So the GAL would still have an obligation to file either a request for an immediate status conference, even if it's filed, on the or prepared on the weekend and filed Monday morning. That obligation would still be present. If the GAL or AMC had a concern about a child's safety, an immediate concern about a child's safety, and wasn't able to reach a court because it's after hours, the GAL would have to do what any citizen would have to do, which would be to contact DCF or the police if there was imminent danger.
Even though the code of conduct does not provide for the GAL contacting DCF.
Well, I don't think that the code of conduct prohibits it either. I mean, I think that you would be within your duty to your ward to protect your ward. But you would have to comply with this code of conduct by requesting that the court intervene as soon as possible.
I think one of the things that the code and the forms recognize is that these cases are all different. Case A is going to be different from case B. And there may be a case where the child is in such danger that we have to call the police. We have to call DCF. But I think that's on a case-by-case basis. That's not something that we can have a rule of thumb for.
Moving to removal of guardian ad litem from a case. What does the code say about that?
So this is absolutely a new provision in the statute which permits a parent to seek removal of a guardian And it ties back to the orders with regard to the guardian's duties. So a litigant can seek removal if a guardian has violated this particular code of conduct or failed to comply with the appointment. And the appointment language is in there because it would assume that the guardian has failed to comply with the orders of duties set forth in the initial order of appointment. So it's a very important and new code of conduct obligation on the part of a GAL to be aware of that there are provisions in place for his or her removal if there's a violation of this code of conduct or the duties set out by the court.
Question I have is, if removal is granted, can the guardian still be called as a fact witness in one of the parties' case in chief? Because he or she has still done some investigation, still is in possession of certain facts and statements from the parties, and simply because they're not offering a recommendation as a guardian, does that automatically disqualify them as a witness as well?
I don't think it would disqualify them as a witness. I certainly think that it would be a difficult position for that particular guardian to be in because they were removed for cause. So there's going to be, obvious cross-examination that would be challenging for the guardian, but I don't think it would disqualify the guardian from being called as a fact witness.
The code of conduct and the new rules are an advance and a significant development for family lawyers. Thank you for watching Case Flash.